In 1965, the nation watched in horror as peaceful marchers were brutally attacked on the Edmund Pettus Bridge in Selma, Alabama, during what would become known as Bloody Sunday. The images of men and women, young and old, facing down state troopers and police batons, shocked the conscience of America and the world. These courageous marchers were demanding the most fundamental right in a democracy, the right to vote. Their determination and sacrifice became a rallying cry for justice, inspiring people across the country to join the movement for civil rights. The outrage that followed Selma led directly to the passage of the Voting Rights Act, or VRA, a landmark law that dismantled decades-old barriers like literacy tests and poll taxes, tools that had been used to systematically disenfranchise Black Americans and other minorities. For the first time, Black Americans in the South and across the nation were able to cast ballots without fear or intimidation, finally gaining a real and meaningful voice at the ballot box. The VRA's federal oversight transformed American politics. It sent federal examiners to protect voters, struck down discriminatory laws, and dramatically boosted minority voter registration. Communities that had been silenced for generations could now participate in shaping their own futures. As a result, thousands of Black officials were elected to office at every level of government, from city councils to Congress, changing the face of American leadership and policy. But the fight for fair representation has never been easy or guaranteed. In 2013, the Supreme Court's Shelby County v. Holder decision struck down a key provision of the VRA, removing the requirement for certain states with histories of discrimination to get federal approval before changing voting laws. This left Section 2 as the last major defense against discriminatory voting practices, making it the critical safeguard for minority voters' rights in the modern era. Now, in 2025, a new Supreme Court case out of Louisiana threatens to weaken this final pillar. At stake is not just a legal technicality, but the hard-won progress of decades and the ability of communities of color to elect representatives of their choice. The case isn't just about drawing lines on a map, it's about whether every community, regardless of race or background, will have a fair and equal voice in our democracy, or whether that voice will be diluted by partisan gerrymandering and discriminatory practices. If the court sides against Section 2, it could open the door to widespread gerrymandering, making it harder for minority communities to be heard and represented. As activists rally outside the court, the echoes of Selma remind us that the struggle for fair representation is far from over. The courage of those who marched in 1965 lives on in every person who stands up for voting rights today. The outcome of this case will shape Congress, state legislatures, and the very future of American democracy for a generation to come. The stakes could not be higher. The right to vote is the foundation of our democracy, and its protection is a responsibility we all share. At the center of this legal battle is Section 2 of the Voting Rights Act, a crucial safeguard in American democracy that has shaped the way elections are run for decades. This section is more than just legal text. It's a living promise that every citizen, regardless of race or background, has a fair shot at having their voice heard at the ballot box. Section 2 acts as a powerful tool, empowering voters to challenge discriminatory voting laws after they're enacted. It's a way for ordinary people to stand up when new rules threaten to silence their communities or make it harder for them to participate in elections. Importantly, plaintiffs don't need to prove that lawmakers acted with racist intent. Instead, they only need to show that a law has a discriminatory effect, especially if it leads to vote dilution, where the power of minority voters is weakened or split apart. For years, courts have required the creation of majority-minority districts to ensure that minority communities have a real opportunity to elect candidates who truly represent their interests and needs. The 1986 Gingles case set the standard for how these protections work in practice, establishing clear guidelines for when and how minority groups can claim their rights under Section 2. Under Gingles, a minority group must be large enough and geographically compact to form a district, politically cohesive in their voting patterns, and, crucially, usually outvoted by the white majority, meaning their preferred candidates would otherwise lose without these protections. This framework has protected fair representation for nearly 40 years, helping to break down barriers and ensure that minority voices are not drowned out in the political process. But now, the Supreme Court is being asked to reconsider and possibly dismantle these long-standing protections. The outcome could reshape the landscape of American democracy, putting the entire structure of fair representation at risk for generations to come. The future of minority voting power hangs in the balance, And what happens next will determine whether the promise of equal representation endures or fades away. Louisiana vs. Calais began with a stark fact. Black residents make up about a third of Louisiana's population, living in communities that have shaped the state's culture, economy, and history for generations. Yet, despite their significant presence, their political power has long been diluted by the way voting districts are drawn. For years, only one of Louisiana's 6 congressional districts was majority black, leaving many black voters with little chance to elect candidates who represent their interests. In response, civil rights groups challenged the map, arguing it violated the Voting Rights Act by denying black Louisianans a fair voice in Congress. After a lengthy legal battle, a federal judge agreed and ordered the state to draw a new map, one that would create a second majority black district, giving black voters a better opportunity to elect a candidate of their choice. In 2024, that new district made history by electing a black Democrat to Congress. For many, it was a long overdue victory for representation and a sign that the Voting Rights Act could still protect minority voters. But the fight was far from over. State officials quickly appealed, arguing that drawing districts based on race, even to comply with the Voting Rights Act, was itself unconstitutional. They insisted that the law put them in an impossible position. According to the state, the VRA forces them into a catch-22. Either violate the act by not creating a second majority black district, or violate the Constitution by considering race in redistricting. This legal paradox has now landed at the nation's highest court. The Supreme Court, with its conservative majority, is now questioning whether any use of race in redistricting is ever permissible, even when it's meant to remedy past discrimination and ensure fair representation. If the court rules against the Voting Rights Act, it could strip away one of its last remaining enforcement powers, making it much harder to challenge unfair maps in the future. As the justices deliberate, the nation watches and waits, knowing that the outcome will shape the future of fair representation, not just in Louisiana, but across America. The Louisiana case pits 2 constitutional principles against each other: the 15th Amendment's promise of no racial discrimination in voting, and the 14th Amendment's call for equal protection. Louisiana argues that creating majority black districts is unconstitutional racial gerrymandering, favoring race-neutral criteria instead. Defenders of the VRA counter that ignoring race ignores the reality of racially polarized voting and entrenched discrimination. The Jingles test exists to address situations where minority voters are consistently outvoted. The Supreme Court could issue a narrow ruling or fundamentally alter the standard for proving vote dilution. A broad decision could end the use of the VRA to create fair maps, leaving minority communities exposed. The court's choice will define the future of voting rights. The debate over Section 2 reveals deep divisions about race and democracy in America. Conservatives argue for colorblind redistricting, claiming the VRA now enforces racial entitlements and divides the nation. They say neutral principles should guide maps, even if it means fewer minority representatives. Civil rights advocates see this as a strategy to suppress minority votes and dismantle the gains of the civil rights movement. For them, the case is an existential threat to hard-won political power. The outcome could determine whether minority communities retain a voice or are pushed back to the margins. The stakes are nothing less than the legacy of the civil rights era. The impact of Louisiana vs. Calais could ripple across the South, where the VRA has enabled hundreds of black and Latino officials to win office. Weakening Section 2 would let states dismantle majority-minority districts, threatening at least 19 Democratic-held seats. States like Alabama, Georgia, and Texas could redraw maps to dilute minority voting power, erasing decades of progress. A sweeping anti-VRA ruling could shrink the congressional Black and Hispanic caucuses and cement partisan control. The loss of these districts would silence millions of voters and reshape Congress for years. The consequences would be swift, severe, and national in scope. The future of Southern representation hangs in the balance. The 2013 Shelby County versus Holder decision gutted the VRA's preclearance, unleashing a wave of restrictive voting laws. Justice Ginsburg warned that removing protections was like throwing away your umbrella in a rainstorm. States quickly enacted voter ID laws, cut early voting, and closed polling places, disproportionately harming minority voters. Section 2 became the last defense, but it's costly and slow, often too late to prevent harm. Now, that final safeguard is under threat. The arguments echo Shelby, that America no longer needs strong racial remedies. If the court agrees, it could erase the very districts that give minority communities a voice. The promise of 1965 risks becoming a relic of history. Weakening Section 2 threatens not just minority representation, but the foundation of American democracy. Without it, partisan gerrymandering would accelerate, silencing entire communities and deepening polarization. Section 2 protects fair representation at every level, from Congress to local school boards. A negative ruling would reverse years of progress in building inclusive, responsive governments. The case forces us to ask, do we want a democracy that reflects our diversity, or one where power is hoarded by a few? The fight for the VRA is a fight for every American who believes in fair representation. A democracy diminished for some is diminished for all. As the Supreme Court's decision looms, voting rights advocates brace for impact. But the fight won't end here. Congress could restore the VRA by passing the John R. Lewis Voting Rights Advancement Act, but political hurdles remain. In the meantime, states may pass their own protections, though progress will be uneven. Grassroots organizing and voter mobilization will be more crucial than ever to overcome new barriers. The defense of democracy depends on public awareness and action. Every generation must fight to protect fair representation. The legacy of Selma endures in those who refuse to give up the fight. The soul of American democracy is on the line.